The Broward chapter of the Paralegal Association of Florida has been committed to supporting paralegals in our community. We would love to see our chapter grow and would encourage you to share the many benefits of PAF membership with paralegals in your life.
Broward PAF has been offering monthly CLEs featuring dynamic speakers covering a wide array of interesting topics. Broward PAF CLEs are offered at no cost for all PAF members, making membership a great value to anyone struggling to fulfill their CLE requirements.
In addition to our CLEs, we host fun networking events that allow you to connect with your fellow paralegals and build friendships that will last a lifetime. Several paralegals in our chapter have reported great career development opportunities thanks to the connections made through the Broward chapter.
Broward PAF is supported by loyal and generous sponsors whose support allows us to hold these events at no additional cost to our members. We cannot thank our sponsors enough for the commitment to building strong relationships with our members.
It's not unusual for our veteran members to offer mentorship to colleagues new to the field or entering a new practice area. It's great to have a community of paralegals to turn to who understand the stresses and rewards of this profession. Getting together to decompress and laugh after a long day is a great bonus of PAF membership.
In 2023, Broward PAF has had the privilege to support community initiatives like the Robin Foundation, which aids women in recovery, Salarillo's Race for the Champions, which benefits the Special Olympics, and Paws to Care Coalition, a dog rescue charity. We can't wait to get together in December for our chapter holiday party and hope you encourage your friends to join us at Broward.
Hi, my name is Tammy, and I'm your paralegal liaison from the Florida Association of Professional Process Servers, otherwise known as FAPS. They've asked me to come here today to give you a quick tutorial on how to find an educated, ethical, and reliable process server here in the state of Florida. So let's get started. FAPS went and created you all your very own landing page for our website. You can simply go to www.faps.org/PAF, and that will take you to a page that looks just like this. This is our website. If you come over here to the right-hand side, you'll see this little person that brings you to a search page. You can search for someone by their name, their business name, or if you don't have that information, you can simply put in a city, state, zip code, however you would like to choose to search. For today's tutorial, knowing that this is online and there are many paralegals all over the state of Florida, let's use the center of the state and go with Orlando, Florida. And there you go, just like that. Now you see a list of process servers that serve in or around the Orlando area, just for you to work with. You may see some of them have this AFPS behind their name. That means that they've gone above and beyond and took the FAPS education class. So therefore they get an accreditation behind their name of the AFPS, which stands for Accredited FAPS Process Server. If that's the person you so choose, you pick on their name, and up comes their information. It provides you with their address, their phone number, and even a hyperlink to their email. And you simply just click on that, and it'll take you right to an email page to where you can send them a message and ask them about their services. Now let's say you want to find a server outside of the state of Florida, because believe it or not, we have servers all over the United States that have chosen to go through our code of ethics to become a member, just like our Florida state members. Go back to your Find a Server button, and now this time let's use the state of New York, and just put NY there for the state, and hit the search button, and up will come all the process servers in the state of New York. Now we could have drilled down a bit further and used a city if we so choose, but now you can see all the servers that we have that are members of the Florida Association of Professional Process Servers from another state. So you can still find that ethical, educated, and reliable process server. And that's it. That's all you need to do to find your servers. And I realize that this is a quick tutorial and you all may have more questions, so please feel free to reach out to me at any time. Once again, my name is Tammy. I am your paralegal liaison with FAPS, and you can reach me at paralegaliaison@faps.org, or feel free to reach out to our administrator. She's always there for you as well. Her name is Diana, and you can reach her at administrator@faps.org. Thank you all. Thank you so much for letting us be here with you. Enjoy the rest of your day and the rest of your conference. Bye-bye now.
My name is Patricia DeRamus. I'm a certified paralegal and a Florida registered paralegal. Been a paralegal for over 35 years. I'm going to introduce the Honorable Jonathan Gerber, Appellate Judge, 4th District Court of Appeal. Judge Jonathan Gerber has served on the 4th District Court of Appeal since 2009, including 2 years as Chief Judge from 2017 to 2019. Before joining the appellate bench, Judge Gerber has served as the Circuit Court Judge of the 15th Judicial Circuit from 2004 to 2009 and as a Palm Beach County Judge from 2002 to 2004. Clerk of Court, 4th District Court of Appeal, Lon Weisblum. Lon Weisblum was appointed Clerk of the 4th District Court of Appeal effective April 7, 2014. Mr. Weisblum currently serves as a member of the Florida Courts Technology Commission and is a member of the Executive Committee of the National Conference of Appellate Court Clerks. He has also served as an appellate staff attorney at both the 3rd and 4th District Court of Appeal. I turn it over now to the Honorable Jonathan Gerber and Clerk of Court Lon Weisblum. Thank you.
Hello, I'm Jonathan Gerber. I'm a judge on the 4th District Court of Appeal, and I've been asked to present an overview of how arguments are effectively presented to an appellate court. Our court's clerk, Lon Weisblum, already has provided an overview of the appeals process, so I'll be focusing more on how arguments are effectively presented through written briefs to the court, starting with the initial brief, and then the answer brief, and the reply brief. The initial brief's contents are controlled by Florida Rule of Appellate Procedure 9.210A and B. The initial brief's contents consist of a cover page identifying the parties to the appeal, the lower court case number, the appellate court case number, and the attorneys filing the brief. A table of contents identifying the headings and subheadings of every section of the brief and the page numbers on which those headings and subheadings will appear. A table of authorities identifying the case law, statutes, and other authorities cited in the brief and the page numbers on which those authorities will appear. A statement of the case and of the facts, more commonly referred to as the facts section, the summary of arguments being made on appeal, followed by a more detailed description of each argument on appeal, a conclusion identifying the relief which the appellant is requesting from the appellate court, a certificate of compliance with the rules of appellate procedure in drafting the initial brief, and a certificate of service on any other parties to the case. The failure to comply with Rule 9.210's content requirements may result in the appellate court striking the initial brief and directing that an amended initial brief be filed, which complies with Rule 9.210's content requirements. In terms of writing the initial brief, the appellant must first decide which arguments to make on appeal. No rule of appellate procedure requires a maximum or minimum number of arguments. One meritorious argument may be sufficient for reversal if the appellant believes that argument is the strongest argument. On the other hand, if the appellant believes more than one argument may be meritorious, the appellant may want to raise all meritorious arguments in the initial brief. However, the appellant must remember that the more arguments which are raised in the initial brief, the less words which the appellant can dedicate to describing the facts and law supporting each argument. In deciding which arguments to make on appeal, the appellant also must consider whether the appellant had preserved the argument in the lower court. That is, made the same argument to the lower court and received an adverse ruling on that argument from the lower court. If the appellant did not make the argument in the lower court, the argument is not preserved. If the appellant did not make the same argument in the lower court, the argument is not preserved. And if the appellant did not receive any adverse ruling or any ruling on the argument from the lower court, then the argument is not preserved. If the appellant did not preserve the argument which the appellant wishes to make on appeal, the only manner in which the appellant can present that argument on appeal would be to characterize that argument as fundamental error, meaning that A, the appellant's fundamental right to due process, meaning notice and an opportunity to be heard, was violated. B, the gravity of the error was so significant that it reached down into the validity of the proceedings to the point that under no circumstances could the jury verdict or final judgment have been obtained without the benefit of the error. Or C, the error is of such a prejudicial character, that is, based primarily on classifications such as race, gender, religion, etc., that it offends traditional notions of justice and fairness to allow the error to stand. The first part of the initial brief, which an appellant should write, is the facts section. By rule, the facts section requires citations to the transcript and or the record for each fact or procedural event described. Failure to include citations to the transcript and the record may result in the appellate court striking the initial brief and directing that an amended initial brief be filed, which includes the proper citations to the transcript and the record. So before writing the facts section, the appellant should review the transcript and the record to determine which portions of the transcript and the record will be relevant to the arguments presented. Then, in writing the facts section, the appellant must follow each fact or procedural event with a citation to the transcript page and the record page from which that fact or procedural event can be verified to have occurred. Again, failure to include citations to the transcript and the record may result in the appellate court striking the initial brief and directing that an amended initial brief be filed, which includes proper citations to the transcript and the record. The appellant's facts section should not refer to facts or procedural events described in the transcript or the record, which will not be relevant to the arguments being presented. Also should not mischaracterize the facts or procedural events described in the transcript or the record, and should not refer to facts or procedural events which are not contained in the transcript or the record. The appellant's facts section also should not omit unfavorable facts or procedural events which are nevertheless relevant to the appellant's arguments on appeal. Any mischaracterizations of the transcript or the record, or any omissions of relevant portions of the transcript or the record. The appellant's facts section also should not omit unfavorable facts or procedural events which are nevertheless relevant to the appellant's arguments on appeal. Any mischaracterizations of the transcript or the record may undermine the credibility of the appellant's arguments in their initial brief. Before writing the facts section, the appellant needs to decide the sequence in which to present the facts. Several different sequence methods exist depending on the nature of the appeal. For example, if the lower court's decision was based on the granting of a procedural motion as a matter of law, like a dispositive motion to dismiss or a motion for summary judgment in a non-criminal case, the appellant likely will want to present the lower court case's procedural history in chronological order. That procedural history should describe the relevant portions of the operative pleadings, the dispositive motions, and any responses. That procedural history also should describe any relevant arguments which the parties made at a hearing on the dispositive motion, any oral ruling which the lower court announced on the dispositive motion, and any written order which the lower court entered on the dispositive motion. As another example, if the lower court's decision was based on a trial or evidentiary hearing in which a jury or the lower court sat as a fact finder, the appellant may want to present the facts in one of two ways. First, the appellant could present the facts by summarizing the relevant portions of each relevant witness's testimony in the order in which each relevant witness testified. This method is generally effective because it allows the appellate court to view the facts in the same order in which the facts were presented to the jury or the lower court. If the basis of the appeal are legal rulings which the lower court heard during the trial, such as the denial of a motion for judgment of acquittal in a criminal case, or the denial of a motion for directed verdict in a civil case, the appellant should describe those events in the chronological order in which those events occurred during the trial. Second, the appellant also could present the facts by weaving the relevant portion of each relevant witness's testimony into a single narrative which describes the factual events in the chronological order in which those factual events occurred. This method can be effective, but under this method, the appellant must be very careful to ensure that the appellant's citations to the transcript and the record are accurate, as different portions of the transcript and the record may be cited from one sentence to another throughout the entire fact section. Again, if the basis of the appeal are legal rulings which the lower court heard during the trial, such as the denial of a motion for judgment of acquittal in a criminal case, or the denial of a motion for directed verdict in a civil case, the appellant could describe those events after having presented the facts in a single narrative. The next section of the appellant's initial brief is the summary of arguments. Before writing the summary of arguments section, the appellant needs to decide the sequence in which to present the arguments on appeal. Again, several different sequence methods exist. However, none of those sequence methods is necessarily better than the others. One method would be for the appellant to sequence the arguments on appeal in the same chronological sequence as those arguments had been presented during the trial. The upside of that method would be the appellate court may have an easier time following the chronological sequence of the arguments. The downside may be that the appellate court may not know which argument the appellant believes is the strongest argument on appeal. A second method would be to sequence the arguments on appeal according to the argument's strength. The upside of that method would be the appellate court would understand which argument the appellant believes are the stronger or strongest arguments. The downside is that the strongest argument may not yield the best result for the appellant. A third method would be to sequence the arguments on appeal according to which argument yields the best result for the appellant. For example, the appellant's primary argument could be an argument which results in the appellate court directing the trial court to enter a final judgment for the appellant without the necessity of a new trial. The appellant's secondary argument could be an argument which results in the overturning of the final judgment but requires a new trial. A third method would be to sequence the arguments on appeal according to which argument yields the best result for the appellant. For example, the appellant's primary argument could be an argument which results in the appellate court directing the trial court to enter a final judgment for the appellant without the necessity of a new trial. The appellant's secondary argument could be an argument which results in overturning the final judgment but requires a new trial. The downside to sequencing the arguments on appeal according to which argument yields the best result for the appellant is that the argument which may yield the best result for the appellant may not be the appellant's best argument on appeal. After the appellant decides the sequence in which to present the arguments on appeal, the appellant's summary of arguments should do just that, summarize the arguments on appeal. Thus, the summary of arguments necessarily will not provide all of the detail and case citations normally found in the more extensive argument section. A good rule of thumb is for the appellant to present the summary of arguments in a manner in which the appellant would want the appellate court to summarize the appellant's arguments in the appellate court's written opinion. Another good rule of thumb is for the appellant to wait to draft the summary of arguments section until after the appellant has drafted the main argument section in order to have a better understanding of how to summarize the arguments which were made. However, keep in mind that Rule 9.210(b)(4) provides the summary of argument should not be a mere repetition of the headings under which the arguments are arranged. The next section of the appellant's brief is the argument section. Each argument in the argument section should be denoted by its own heading. Any sub-argument should be denoted by its own subheading. The appellant should begin each argument or sub-argument by stating the appellate court's standard of review of that particular argument or sub-argument. Several different standards of review exist depending on the nature of the argument or the sub-argument which the appellant is presenting. For example, arguments based on law, which generally arise from the granting of dispositive motions in civil cases, such as a motion to dismiss and a motion for summary judgment, are subject to what is called de novo review, meaning the appellate court reviews the argument on appeal in the same posture as did the lower court, without giving any deference to the lower court's decision. Arguments based on the lower court's exercise of its discretion over scheduling and other procedural matters are subject to what is called abuse of discretion review, meaning the appellate court generally will defer to the court's exercise of its discretion unless the appellate court concludes that no other reasonable judge would have exercised their discretion in the manner in which the lower court exercised its discretion. Arguments based on the lower court's evidentiary rulings, such as whether a witness is qualified to testify, whether a witness's testimony is admissible into evidence, and whether documents or other tangible objects are admissible into evidence, are also subject to the abuse of discretion standard of review, but that standard of review is limited by the rules of evidence and case law interpreting the rules of evidence. In other words, the appellate court's determination of whether the lower court abused its discretion in rendering an evidentiary ruling will depend on whether the lower court's ruling complies with the applicable rule of evidence and case law applying that rule of evidence. Arguments based on whether sufficient evidence was presented to support the lower court's factual finding or a jury's verdict is subject to a competent substantial evidence standard. For evidence to be competent, the evidence must have been presented by a witness who is qualified to have provided such evidence, either through personal knowledge or by specialized training and experience as an expert. For evidence to be substantial, the evidence must have provided sufficient credibility and weight for the lower court or the jury to have based its factual finding or verdict on that evidence. As stated earlier, arguments which were not preserved in the lower court are subject to fundamental error review, meaning that A, the appellant's fundamental right to due process, meaning notice and an opportunity to be heard, was violated. B, the gravity of the error was so significant that it reached down into the validity of the proceedings to the point that under no circumstances could the jury verdict or final judgment have been obtained without the benefit of the error. Or C, the error is of such a prejudicial character that is based primarily on classifications such as race, gender, religion, etc., that it would offend traditional notions of justice and fairness to allow the error to stand. After stating the appellate court's standard of review for that particular argument or sub-argument, the appellant would then articulate the argument or sub-argument in detail by stating the applicable law and then applying the relevant facts to the applicable law. The argument section thus will contain citations to any applicable statutes, rules, and case law. The appellant's argument section should not omit citations to unfavorable statutes, rules, and case law, which nevertheless may be relevant to the appellant's argument on appeal. The appellant's burden is to explain why those unfavorable statutes, rules, and case law may not be directly applicable to the arguments on appeal. Omitting citations to unfavorable statutes, rules, or case law, which nevertheless may be relevant to the appellant's arguments on appeal, may undermine the credibility of the arguments being made in the appellant's initial brief. Any citation to a statute, rule, or case law must be accurate. Any mischaracterizations, intentional or not, of a statute, rule, or case law may undermine the credibility of the arguments being made in the appellant's initial brief. The final substantive section of the appellant's initial brief is the conclusion. The conclusion provides the appellant with the opportunity to identify the relief which the appellate court can provide if the appellate court agrees with any of the appellant's arguments on appeal. As mentioned earlier, the relief which the appellant may request will depend upon the nature of the argument to which that relief may apply. The appellant's final actions in completing an initial brief generally are technical in nature, that is, preparing the table of contents to mirror the headings and subheadings of every section within the initial brief, and identifying the page numbers on which those headings and subheadings appear, preparing the table of authorities listing the case law, statutes, and rules which are cited within the initial brief, and identifying the page numbers on which those authorities appear, preparing the certificate of compliance with the rules of appellate procedure for drafting a brief, and finally, preparing the certificate of service on all other parties to the appeal. Now let's turn to the appellee's answer brief. The appellee is bound by many of the same rules of appellate procedure in writing the answer brief. Thus, the appellee should read the rules of appellate procedure, especially those rules which describe the appellee's duties to A, request the clerk of the court to timely deliver to the appellate court a supplemental record of any lower court proceedings which the appellant did not request be included in the record, but which the appellee believes will be pertinent to the arguments on appeal. B, request the court reporter who transcribed the lower court proceedings to deliver to the appellate court the transcripts of any additional proceedings which the appellant did not request to be delivered to the appellate court, but which the appellee believes will be pertinent to the arguments on appeal. And C, file an answer brief. Rule of Appellate Procedure 9.210G provides that the answer brief must be filed within 30 days of the appellant having served the initial brief on the appellee. Like the appellant, the appellee also may file a motion for extension of time to file the answer brief. The appellate court is not required to grant any motion for extension of time to file the answer brief. However, if the appellate court grants an extension of time to file the answer brief, that extension of time may be limited. Failure to file the answer brief within the extension of time may result in the appellate court, on its own motion, precluding the appellee from filing an answer brief. The answer brief's contents are controlled by Rule of Appellate Procedure 9.210C. The only difference between the answer brief's contents and the initial brief's contents are that the appellee does not need to include in the answer brief a statement of the case and of the facts, more commonly referred to as the facts section, if the appellee believes the initial brief's facts section has adequately and accurately stated the relevant facts and procedural events. However, if the appellee believes the initial brief's facts section has not adequately and/or accurately stated the relevant facts and procedural events, the appellee may provide their own statement of the relevant facts and procedural events, or merely indicate which of the initial brief's statement of the relevant facts and procedural events require supplementation and/or correction. Failure to comply with Rule 9.210C's content requirements may result in the appellate court striking the answer brief and directing that an amended answer brief be filed, which complies with Rule 9.210C's content requirements. An appellate generally should, but is not required to, track the initial brief's sequence of arguments to assist the appellate court in better evaluating each side's differing positions on each argument. However, if the appellant's initial brief has misidentified or has omitted how the appellant preserved an argument on appeal, the appellee's answer brief may include an argument identifying why the appellant did not preserve the argument on appeal. Further, if the appellee believes the appellant's initial brief has misidentified or has omitted the standard of review, the appellant's answer brief may identify the correct standard of review. Also, if the appellee believes the appellant's initial brief has misrepresented or has omitted applicable statutes, rules, or case law, the appellee's answer brief may correct the appellant's misrepresentation or provide the court with additionally applicable statutes, rules, and case law. Now let's turn to the reply brief. After the appellee has filed an answer brief, Rule of Appellate Procedure 9.210 provides that the appellant may file a reply brief within 30 days of the appellee having served the answer brief on the appellant. The appellant may file a motion for extension of time to file the reply brief. The appellate court, however, is not required to grant any motion for extension of time to file the reply brief. But if the appellate court grants the extension of time to file the reply brief, that extension of time may be limited. Failure to file the reply brief within the extension of time may result in the appellate court on its own motion, precluding the appellant from filing a reply brief. The reply brief's contents are controlled by Rule of Appellate Procedure 9.210D. Rule 9.210D allows the appellant to reply only to those arguments which the appellee has raised in the answer brief. The appellant's reply brief is not allowed to raise new arguments on appeal, which the appellant had not included in their initial brief. If the appellant's reply brief raises new arguments on appeal, which the appellant had not included in their initial brief, the appellate court will treat those new arguments as having been waived by the appellant. So to wrap up, what does a well-written brief look like? A well-written and effectively persuasive brief is well organized into appropriate sections and subsections so that the brief does not read as one unorganized long narrative. So to wrap up, what does a well-written and persuasive brief look like? A well-written and persuasive brief is well organized into appropriate sections and subsections so that the brief does not read as one unorganized long narrative which continues on for dozens of pages. Each section and subsection are written with as few paragraphs as possible to convey one topic at a time. Each paragraph is written with as few sentences as possible to convey one topic at a time. And each sentence is written with as few words as possible to convey one topic at a time. The goal is to allow the reader to read the brief in small pieces, one at a time, so the reader is able to digest the information, understand the information, and maintain the information as they continue reading the brief. The best compliment which can be given to any brief is that the brief is so well written that the appellate court does not have any questions to ask because the brief has provided all the answers. Thank you.
Hello, my name is Lon Weisblum. I'm the clerk of the court of the 4th District Court of Appeal. Thank you so much for having me today. When I speak to attorneys, I often tell them that I'm going to give them a lot of important information and they need to convey that information to the staff in their offices. So this is even better because I get to convey that information directly to you today. So thank you for having me. I'm very happy to be here. So as far as what I'm going to talk about today, I'll tell you a little bit about myself and my team in the clerk's office at the 4th DCA, how to get your appeal off to a good start, about electronic filing, how to handle the statewide portal, some new appellate rules that you should find important, certificates of service, and interacting with us at the clerk's office in an appellate court. So let's just talk about the team at the 4th DCA. First of all, you have myself, I'm the clerk of the court. I have a chief deputy clerk. We have 2 staff attorneys, and then we have 11 deputy clerks that handle all the various different stages of an appeal that you can see there on the screen. So it's a team effort. It's a small office compared to a county clerk's office, but we get the job done and we want your case to move through very efficiently. A little bit about myself. I have a BA in psychology from the University of North Carolina at Chapel Hill. I went to law school at the University of Florida, and I have worked as an attorney both at the 3rd and 4th District Courts of Appeal, and I've also spent some time in private practice. And as the clerk, I'm also a member of the Florida Courts Technology Commission, and I'm on the executive committee of the National Conference of Appellate Court Clerks. So that's a little bit about me. And now let's talk about what you're really here for, to find out how to get an appeal through. So first thing is to get your case off to a good start. When you file the notice of appeal, you file it immediately after receiving an unfavorable final decision or an appealable non-final decision from the lower court. What you need to do is make sure you read the rules of appellate procedure to determine the deadline for the appellant to file the notice of appeal. It's very important to understand what that deadline is, because if you don't file a timely notice of appeal, the appellate court could dismiss the appeal as untimely filed. So that's very important. The notice of appeal should be filed not with the appellate court, but with the clerk of the lower tribunal, or in other words, the county clerk. And the clerk of the lower tribunal will transmit the notice of appeal to us at the appellate court. That's how the system will work. But you're not done once you start an appeal. After you file the notice of appeal, you want to look at the rules of appellate procedure, and you want to focus on 3 things. There are 3 things you need to do to get an appeal moving. First thing is to file directions to the county clerk to include or exclude information in the appellate record, which could include other documents or exhibits filed in the case. If a court reporter was involved, you want to be able to file a designation to the court reporter to transcribe the portions of the proceedings that were necessary for transcription inclusion in the record. So you've got the directions to the county clerk, you've got the designation to the court reporter, and then once you have all that, you have what's going to happen with the record. Later on, you're going to file an initial brief. That's basically where the attorneys make their argument to the court for why the case should be reversed. And of course, though, when you're dealing with an appeal, you need to make sure you pay your fees. So you need to pay the fees due to the clerk of the lower tribunal, to the appellate court, we have our own filing fee, and to the court reporter if there's a cost associated with preparing the transcript. So make sure that all the financials are up to date so the case gets off to a good start and keeps moving. So now let's talk a little about electronic filing to the appellate courts. Incoming filings, they're filed and should be served through the statewide portal. Outgoing filings, in other words, the court's orders, opinions, and mandates, those are sent through something called CTRAC CMS email. One big thing you want to make sure of is that the court has up-to-date email addresses for all of the attorneys, which also could include you. So we allow attorneys to have up to 3 email addresses. Many attorneys have their email address plus the address of 1 or 2 assistants to make sure that everybody is covered and gets everything. The one misconception is that we're somehow tied into the statewide portal for outgoing filings. We are not. So even though the portal may have the correct addresses for your attorney, we may not have it at the appellate court. So make sure that we have up-to-date email addresses for each attorney. And then as far as attorney and party docket access, that's through a system called ACES. Please be sure that all the attorneys in your office are registered. Again, like I said, provide up to 2 additional email addresses that we can use for service of filings. Once the attorney is registered, any case where they're attorney of record, they can go in, log into ACES, and see all of the relevant documents on the case. There's no need to request access to cases on a 1-by-1 basis. And again, attorney's counsel of record, that case will show up in their ACES account, including new cases. I did also want to show you the e-filing map for the courts, and you can see all the different districts. And then at the bottom of the screen, you can say which court you're going to, and in the drop-down, pick which court you're filing to. So that's how you would handle filing to the appellate court. Now let's talk about another feature of the statewide portal. At the statewide portal, you can pay your appellate filing fees electronically. And this is very convenient, not only for the attorneys, but for the court as well. We can process the filing fee faster, and there's less of a risk. When you send a check, we might not get it. The mail might not be as reliable as you're expecting it to be. So to quickly and easily pay the filing fees, we very much recommend paying electronically through the portal. And then the other thing to remember with the statewide portal is that you can file multiple PDFs in one submission. So if you have a brief, an appendix, and a motion for attorney's fees that you're filing, you can file them in the same submission. There's no need to do 3 separate submissions. It's actually more efficient for us to get them in a group. This way we make sure everything gets docketed timely and efficiently, and we can see everything together. So some more thoughts about electronic filing and portal. So first of all, like I said, you can file multiple PDFs in one submission. The combined size can be no more than 200 megabytes. And if the combined size is more than 200 megabytes, you want to file in multiple submissions. If an individual PDF exceeds 200 megabytes, which is usually going to be an appendix, please contact the appellate court clerk's office before you break the PDF into multiple parts. We might be able to give you some guidance on how to handle it. And then for e-service, know that the portal divides the file into a 10 megabyte file, 10 megabyte file services, and sends out an email for every 10 megabyte file. So rather than doing that, let's suppose somebody makes a big filing, you're best off logging on to ACES and download the filing in the entirety, rather than trying to put a bunch of small PDFs together. Much more efficient. And then finally, let's talk about emergencies. In the appellate courts, just like in the trial courts, you've got an emergency / time sensitive filing box. Number one, please don't mark a filing as an emergency if it's not an emergency. I know some people will do that in the trial courts to try to skip the line and get their filing handled first. Please understand we don't have that level of volume in the appellate courts. And if you file an emergency, file a non-emergency and check the emergency box, that's really not something that's looked upon very favorably. So please don't do that. The court will process the filing efficiently. You don't need to mark it as an emergency. One thing about emergency filings, the 4th DCA, is that those filings require a request for emergency treatment to be filed. That's where the attorney needs to explain why the court should drop everything to take a look at the filing that the attorney wants to bring to the court's attention. That's a 4th DCA only thing, not the other appellate courts. And then also, please use your discretion when marking a filing as time sensitive. Avoid using that box unless it truly is a critical thing going on. And now we're going to talk about some new appellate rules that might be relevant to the attorney's practice. So first one, Rule 0.9100D, the notice of appeal must state if a motion postponing rendition is pending and the date it was filed. So an example of a motion postponing rendition is a motion for rehearing and pending in the trial court. So we can't move our appeal forward till that motion for rehearing is dealt with. So that's why we need to know if there's one of these motions being filed from the outset of our appeal. The record will be transferred by the lower tribunal clerk within 60 days of the filing of the notice of appeal in non-criminal cases. Take a look at the rules for criminal cases because that's based on what's been filed earlier. But in most non-criminal cases, the record should be transferred within 60 days of the filing of the notice of appeal. Another big rule, Rule 9.045B. The font for all computer-generated documents, which means not only briefs, can be Arial 14 point or Bookman Old Style 14 point. So that means if in the trial court you're used to using Times New Roman, for the appellate court, you need to switch to Arial or Bookman. I know at least at the 4th DCA, we will strike filings for non-compliance with that font rule. So please pay attention to that. And then finally, there's some various rules, but the big thing was that page limits were replaced with word counts for computer-generated briefs, petitions, and responses and replies. So take note of that. It's not about pages anymore. It's about a word count. And then another thing I wanted to talk about that we often see and we have to strike filings for is a non-compliant certificate of service. A non-compliant certificate of service fails to list attorneys and their information. Or in other words, a lot of times they'll just merely refer to the portal service list. So for example, if you see the certificate of service at the bottom of my screen, all it says is that we served everybody on the e-filing portal service list. That's great, but we don't know who you served. And so we want something more detailed that's required by the rules. You need to say who was served, who they represent, what their email address was, and what their physical address is. So very important that you do that because we need to know who exactly was served with it. Because like I mentioned earlier in the presentation, the portal service list is not connected to our systems. So it's important that you identify who you serve. And so the last thing I'm going to talk about today is interacting with the clerk's office. If you ever have a question, please don't hesitate to call the appellate court clerk's office, although there are some limits to what we can tell you. So the clerk's office can provide case information. Those are things like when a pleading was filed, copies of documents, case numbers, information about court practices. So case information we can provide. We could not provide legal advice, and legal advice does have a very broad definition. That includes calculation of deadlines, interpreting rules of procedure, elaborating on a court order or court opinion, how you should respond to a pleading filed by the other side, or predictions about how or even when the court will rule. So there is a dividing line, and the idea of legal advice is very broad. So if you're asking for information about a case, that's the key, and that will get you the information that you need. So that's all I have. Thank you so much for having me present to you. I hope you found this information very helpful and that you'll be able to apply it back at your offices. Thank you so much.